Hello everyone, my name is David and currently I'm working at the Professorship of Law, Science and Technology at TU Munich. First of all, thank you for giving me the opportunities to speak at this wonderful conference and to be part of the various presentations we already heard so far. Today I want to speak with you about access to justice by design, or more specifically, legal design, which is the topic I'm pursuing in my PhD project. So please sit back and enjoy. Justice at its core concerns itself with who deserves what and why. For this reason, contemporary global justice scholars deal with the worth of the individual, regardless of place and birth and other factors, and focus on contexts in which individuals are not yet treated as equal. To engage with such problems, global justice scholars usually focus on what individuals across the world deserve and how the distribution of these entitlements can be achieved. While this has been connected with economic redistribution traditionally, scholars like Amartya Sen shed a light on subjective rights for achieving global justice. He argues that true development should not only be measured by economic indicators, but that people's abilities and freedoms should take center stage. He argues that in order to achieve global justice, we need to improve political and social structures in order to promote human rights and thus create a fairer world. Importantly, Sen's approach emphasizes fundamental rights and equal opportunities as the basis for promoting justice on a global level. Global justice, therefore, is very much connected to subjective rights. On the slide next to me, we can see how issues that hinder global justice, like poverty, hunger, or gender inequality, can be translated into subjective rights. These examples make clear why the idea of human rights often forms the basis for discussions about global justice. The idea is that if these basic rights are protected and respected for all people, a fairer and more humane world can be created. An important component of global justice is access to justice. The connection between the concept of access to justice and global justice is simple. Achieving global justice requires addressing disparities and ensuring that individuals around the world have equal access to legal mechanisms and remedies. This requires both material justice in the sense of human rights and access to justice as its procedural counterpart. Inequities in access to justice can contribute to and perpetuate global injustices. For example, if certain groups or individuals lack access to legal recourse, they may be more vulnerable to exploitation, discrimination, or other forms of injustice. Efforts to promote global justice therefore often involve addressing barriers to access to justice at both a local and international level. This may include addressing issues such as the provision of legal aid, legal education, and the protection of human rights. This is also the reason why the UN fixated access to justice in their portfolio of human development, the Sustainable Development Goals. We can conclude, therefore, that access to justice is an important right for itself and maybe even more importantly, an enabler for other rights and is therefore crucial for achieving global justice. If things would be so easy, I could stop my presentation at this point. The problem is when we do research on access to justice is we discover a disconnect between the theoretical or normative concept of access to justice, or the so-called law in the books, and the reality of access to justice. In a lot of contexts, people did not pursue their rights even though the law grants them access to justice. This happens for various reasons, including the inability to understand the law or the legal system, amongst others. After realizing this gap, beginning in the second half of the 20th century, experts not only of the legal domain tried to close this gap between the before mentioned law of the books and the reality by various, oftentimes activistic approaches, which I call hands-on approach, because of their emphasis on reality. These included the plain language movement, focusing on simplifying legal documents and making clear what the law actually says, or the free access to law movement, which tries to educate people about their rights. A rather recent idea in this area of delivering real access to justice is legal design. The emergence of legal design comes at a time when lots of elements in our society are changing due to new demands of their users. Old processes give way to new ways of working and doing business. Just think of the way Amazon has changed our view on shopping. Legal design is a symptom of these demands and their corresponding methods within the legal system. It is situated between three cornerstones: the law, creativity, and humans. The basic idea is to bring these three systems into a position where they interact with one another in order to change the legal system with the help of design methods and thinking. This can include, for example, legal products like a contract or the way a court handles new complaints. The law can be considered the canvas of the creative process. Creative methods and ideas should change the legal system in meaningful ways. The human sits on top of these elements for two reasons. He is necessary to initiate the process of redesigning the legal system, and he is the goal that any change or redesign should have in mind. One important aspect of legal design is human-centeredness, which means to design with the user or in this context, the person who seeks justice at the center of attention. This is a radical change for today's design of the law, where oftentimes legal structures are created by experts for experts, but not for the people that are actually concerned. We can therefore call legal design the combination of a human-centered design approach to the challenges and structures of the legal system. The following slide shows how legal design can work in practice and which elements are important to achieve user-centeredness on the example of redesigning the process of filing a complaint at a court. A first but important step for any successful attempt of a design process is to build the right team. In order to achieve lasting change, any group has to consist of all people that are affected by the particular element of the legal system. In our case, this shall include law seekers, lawyers, and judges, but also other stakeholders like clerks or other people working at the court. The next step is to understand the issue at hand from the perspective of the user properly. In our case, this means hearing exactly what people bothers, why the process is not working for them. Central to every design is its iterative and preliminary nature. That means that any solution has to be prototyped, tested, and reconfigured according to the results of the trials period. We have to find out what works in the real-life situation and not only on paper. The final step is implementation. One possible solution to make the complaint system less confusing in our case should be a clear visual mapping of the process any claimant has to go through with additional low-level human and digital assistance. Now, let us look at the concept I provide in my thesis. The central idea of my thinking is the connection between the notion of access to justice on a theoretical level and legal design. In my work, I investigate this relationship. Legal design, the idea of human-centeredness and its practical methods change the way we think about access to justice as a concept. On the other side, access to justice has also implications on legal design. What role should legal design play within the legal system, especially with the experiences we make become more and more influenced by digitization? Within my thesis, I hope to shed light on the interplay and the reciprocal influencing of these two concepts. A first step for coming up with an answer to this question is to investigate what is already out there. In the beginning, I told you that legal design is one of the key ways to close the gap between the theory of access to justice and its practice in many circumstances. So maybe legal design is an old hat after all. For this, we have to look at real-life projects in the domain of legal design and access to justice initiatives. When comparing these two elements, it becomes clear that on the one hand, legal design projects address issues that are also of concern in the access to justice realm. On the other side, there are a lot of methods that projects that have access to justice as their goal intuitively use methods one would ascribe to the field of legal design. Ultimately, it becomes clear that these two fields have more in common than it initially seems, at least when it comes to their application in concrete initiatives. The question remains, however, if we integrate legal design into the portfolio of access to justice also on a theoretical level. Just because access to justice and legal design projects have much in common does not mean we have to include legal design into our conception of access to justice. If we do so, the first question is, what should it achieve? What do we want legal design to be? This question can only be answered if we examine the meaning of access to justice in more detail from a procedural perspective. One possible answer could be that access to justice means that everybody has the formal right to file a complaint before court with no assistance beforehand. This is a very reactive approach. with little amounts of resources on the side of the justice system needed. A step further would be enabling access to courts in the sense of making sure that everybody has a real chance of filing a complaint if he or she discovers a legal issue. This understanding would require more resources, as there would be the need to assist earlier and more meaningful in the process of accessing the justice system. The most proactive understanding of the term would be that the justice system is required to make people aware of their subjective rights and their corresponding legal issues. This would require extensive resources, since the integration of accessibility would have to be within the daily life of people. The answer of this question shapes the deployment and impact legal design is expected to have within the legal realm. Multiple legal documents such as the German Basic Law, which is the German Constitution, or the Convention on the Rights of Persons with Disabilities of the United Nations portray these different widths of the concept. Whereas the German Constitution states that access to justice has to be, quote, effective, it does not demand a proactive stance towards access to justice, as only some needs for assistance, especially economic ones, are recognized. Article 13 on the Convention goes further and requires appropriate training of court personnel with regard to people with disabilities, and therefore recognizes the need for a more proactive approach to achieving access to justice. The answer to the question of the width of access to justice, as laid down in the law, is one of the necessary assessments to conclude whether design is an obligatory component of the concept of access to justice. In other words, if we assume the narrowest possible interpretation of access to justice, the possibilities that legal design brings are not needed. Furthermore, one can also ask whether it is even possible to implement a regulation of access to justice by legal design, since the only comparable context of the mandatory implementation of a legal value with the help of design is privacy by design, as it can be found in the GDPR. Finally, we could also think of competing legal interests, such as the freedom of the legislature to achieve access to justice in other ways, or the risk of overburdening the court system. To conclude, from my point of view, legal design can contribute in a meaningful way to access to justice and therefore is one of the most promising approaches to achieving global justice. I want to conclude this presentation with these two citations from two of the most influential scholars of the field, since if you do not trust my expertise by now, you may at least believe them. Thank you very much. This marks the end of my presentation. Now I'm looking forward to your remarks and questions. Thank you.